In this chapter, we're going to talk about homicide cases in court. So remember that in a pretrial stage of any criminal offense, but in particular murder, the district attorney has a great deal of discretion, which means they actually have a lot of power. This is the person who's going to decide not only whether or not to charge somebody, but also what crimes to charge them with. So you could be charged with anything up to the most serious crime for which there is evidence, or you could be charged with a lesser offense. Oftentimes, in most cases, someone is facing multiple charges. So in 2003, 61% of defendants charged with murder in the 75 largest urban counties were charged with at least one additional felony. And finally, the DA could decide not to charge somebody at all. So within 48 hours of arrest, someone has to have what's called an initial appearance. They have to be brought before a judge or magistrate, and in the initial appearance, they're formally advised of the charges against them. At this stage, if they need an attorney may be assigned to them, and a judge may decide to set bail. If the accused has been arrested without a warrant, a probable cause hearing must also take place within 24 hours. More often than not, though, the PC hearing and the initial appearance are included together. So in some counties, or in some cases, someone may be granted pretrial release. Bail and release on your own recognizance is less likely in a homicide case. Of course, homicide cases are one of the most serious charges with which someone can be charged. Nearly 3/4 of those eventually convicted of murder had been denied bail or had a bail amount that was set at least $100,000. And that's obviously a bail amount that's prohibitive for most people. Some states have even instituted laws that don't allow pre-release for those believed to be a danger to society, and certainly people accused of committing murder would probably fall into that category. Another stage that might happen is a grand jury. So a grand jury meets in advance, and their whole purpose is to hear potential charges against people and to decide whether or not to indict somebody, which would mean to bring them to trial. So grand juries meet in secret, and the defendant doesn't have a right to attend. They don't have a right to present evidence. And in fact, in most cases, they're not even going to know that a grand jury has been convened against them. In most cases, the grand jury believes there's enough evidence to proceed with the case because these are grand jury proceedings are incidents in which the prosecutor is basically going to lay out the evidence against somebody. Because the defendant doesn't appear and because the prosecutor is allowed to use evidence and information that wouldn't be admissible in trial, more often than not, a true bill is returned. And a true bill means that the defendant has been indicted. It's pretty rare that grand juries don't indict somebody. The next step would be arraignment, and at this stage, the defendant's going to enter a plea. If they admit to guilt, then they're admitting to the act, and the judge would next move to schedule a sentencing hearing. If they plead not guilty, then the prosecution is going to have to move forward to prove the case against him or her at trial. You can also enter a plea called nolo contendere, which means no contest. Basically, if you plead nolo contendere, you're saying that the state has sufficient evidence to prosecute you, but you're not admitting to guilt. Now, this seems a little odd because what would really be the benefit here? Because you're still going to be punished. But the benefit has to do with not having an admission of guilt on the record in terms of a potential civil trial. So if somebody were to try you civilly for wrongful death, then your guilty plea couldn't be used against you as an admission of guilt. Even if a defendant or a suspect has confessed to the police, they're still able to enter a plea of not guilty. Now, in between this initial plea and what's going to happen at trial, we could have several pretrial motions that could be filed, and we might also have a plea bargain. In fact, in most cases, we will have a plea bargain. Somewhere around 90% of all cases are bargained out. So a plea bargain has to be approved by the judge. Just because the DA and the defense have agreed to it doesn't mean it's automatically going to go through. And reason someone would take a plea bargain is to avoid any risks that might happen at trial. And essentially, generally what's going to happen is you'll be allowed to plead to either a lesser offense or the same offense and get a lesser punishment. And this is common even for people charged with murder, non-negligent manslaughter, and other violent crimes. So 68% of people with a homicide conviction did plead guilty. Both sides are going to file pretrial motions, and this is where they're making a request of the judge. So, for example, defense attorneys will often make a motion for discovery, and that's a motion to have the prosecution hand over to them any evidence in the case. They may also move to have particular pieces of evidence suppressed so that they can't be introduced and used at trial. If a court date is set and the defendant has pled not guilty, we need to select a jury. And our Sixth Amendment guarantees us a right to an impartial jury. Jurors are selected from what's called a veneer, and that's the group of potential jurors. And the veneer is supposed to be representative of the community from which it is selected. Both the defense and the prosecution are going to try to exclude jurors that appear to have extreme views. So usually a jury has 12 members and 2 alternates, and the reason we have alternates is in case one of the other jurors has to be dismissed during the trial. The veneer is then summons to court for voir dire, which means to speak the truth, and this is when we get summons to court, we call this jury duty. Voir dire aims to discover whether there's reasons for excluding particular individuals from the jury. And you could be excluded one of 2 ways. So you could be excluded with what's called a challenge for cause. And both sides have unlimited challenges for cause. But what you have to be able to do in order to exclude somebody for cause is to show that they are impartial or have some conflict of interest. Peremptory challenge, on the other hand, don't require you to submit a reason, but they are limited. One thing that happens a lot today is what's called scientific jury selection, and this actually dates back to the early 70s. Schulman conducted survey and interview research in order to develop demographic profiles of those most likely and least likely to side with the prosecutor. And it's been successfully used in trials. Jury selection is a $400 million industry, and practitioners charge anywhere from $2,000 to over $100,000. So this is generally, a process that's used by wealthy defendants. Research tells us that personality and demographic variables that social scientists have studied only account for about 15% of any variance in verdicts. Studies do show us, though, that the nature and presentation of evidence is important in jury decision-making. One problem, though, is that college students are often used as samples here. If you have taken research methods, you might recall that college students are used for samples for a lot of research because a lot of research is done by university professors and faculty, and college students are readily available to them. However, if being in college is not an element of what you're studying, then these samples actually can't be applied, or the results from them can't be applied to the general population. So college students might not be called for jury service all that often. Once a trial begins, both sides are allowed to present an opening statement, and these are arguments and they are not considered evidence in the case. The onus of proving the case falls to the prosecutor, and the defense doesn't have any obligation to prove their innocence. But they usually want to do this anyway. Both sides will present both direct and circumstantial evidence. And direct evidence proves a fact directly. So a 16-year-old Michigan boy films himself cutting off a man's head. That's direct evidence that he has cut the man's head off. Circumstantial evidence often gets a bad rap. You'll hear people say things like, oh, but it was a circumstantial case. Circumstantial case requires you to deduce what happened from the evidence that's been provided to you. So think about the Scott Peterson case. No one saw him kill Lacey Peterson, and a weapon was never found, but they relied heavily on testimony from Amber Fry. Here's an example of circumstantial evidence that might make more sense to you. You go to bed at night, there is no snow on the ground. You wake up in the morning, there is snow on the ground. You will probably deduce that it snowed while you were sleeping. Well, that's circumstantial evidence, versus you looked out the window and saw it snowing, which is direct evidence. Both sides have many procedural rules they have to follow when presenting their cases. So hearsay, which is a fact offered by someone other than the person who saw or heard it, is not admissible in court. If you want to use expert witnesses, there's rules in determining who's considered an expert. So in 1993, Dober versus Merrill Dow was a case that gave judges more power in determining what would be considered scientific evidence and if it would be admissible at trial. Most states, however, follow the Fry standard, and this says that scientific evidence, so this is anything from blood spatter to profiling to fingerprints to bullet marks, has to be based on accepted scientific techniques. The President's Commission on Science That's not actually the full name of it. But they recently came forward with a large report saying that a lot of the scientific evidence that's been used in court hasn't actually been thoroughly tested. Doesn't mean that it's not reliable, but we haven't done enough empirical studies of it. So after the prosecution has presented its case, the defense can move for a directed verdict. They can basically ask the judge, look, the prosecution didn't prove their case. We move for you to acquit. What also could happen is a mistrial can happen. And if a case does result in a mistrial, the prosecution is able to retry the case. They don't always do so, but they do have the option to do so. So you've been accused of murder. What defenses are available to you? Well, you have an alibi. And this is an argument that you were somewhere else, right? Alibi literally means elsewhere. And basically what's going to happen is the judge or jury will determine if you present evidence of an alibi, if it's valid. So Juan Catalano was charged with murder, and he was awaiting trial for 5 months in jail. During the murder, he was seen at a Dodgers game and had ticket stubs. Curb Your Enthusiasm was taping, and in one shot, Catalano can be seen eating a hot dog at the game. The timestamp from the tape and cell phone records led to the charges being dropped because they were able to place him at this game as opposed to at the location of the murder. We also have what's called justifications and excuses. Okay, justifications is a case where someone admits they killed the victim, but it was necessary to prevent a greater harm. Excuses where someone is admitting they committed a crime, but argue they're not legally responsible for it. So let's look at these. As far as justification goes, one is consent. The victim gave their permission. This doesn't apply in murder cases, but say you're playing a sport that is, physically aggressive, where there's a lot of physical contact, where someone might be assaulted. One would argue that that involved consent. Necessity is where we commit a crime to prevent a greater harm. So there was a case where 2 shipwreck survivors killed the 3rd survivor in order to eat him for survival. This is an argument that isn't really accepted in court. And in that particular case, the manner in which they chose who to kill to eat for survival made it invalid. Self-defense and defense of others, this is probably the most appropriate defense for murder. In order, though, to argue self-defense or defense of others, you have to use reasonable force when you reasonably believe the other person is threatening you with imminent unlawful harm. This can be difficult for a jury to decide. And in terms of defending others, you cannot defend a person who started the altercation. So if the person you're defending started the altercation, it's no longer considered defense of others. Defense of home and property is usually not allowed for a case of murder. Some states allow it as part of their stand your ground laws, which allow you to shoot an intruder who enters your home. And basically under those laws, the police cannot arrest or detain you. And you cannot be prosecuted for killing an intruder who has unlawfully and forcefully entered your home. But some people feel this gives someone a license to kill. Excuses include things like age. Children under the age of 7 are generally deemed incapable of forming mens rea or criminal intent. Those between the ages of 7 and 14 can use age as a defense, but it can be refuted. If you have been drugged against your will, this would also negate mens rea. Provocation is another excuse, and this could reduce a murder charge or conviction to a manslaughter charge. You have to show that the defendant was acting as any other reasonable person would and lost their emotional control because of some provocation on the part of the victim and did not have sufficient time to cool off. Insanity is also an excuse, and this is a legal, not a medical term. You can't go to the doctor and be diagnosed as insane. So one thing to think about too is insanity is different from being competent to stand trial. Competency to stand trial means the person is capable of understanding the charges against them and the proceedings against them, and they can aid in their own defense. Insanity is arguing that you have some mental defect or mental illness that basically cancels out your ability to form criminal intent. Very few people are found not guilty by reason of insanity, and when you are, you're committed to a psychiatric facility, and you could be there for a very long time. Most states follow the Monotone rule, which is one test for insanity. And the Monotone rule basically says, due to mental disease or defect, the offender did not know what they were doing was wrong. There's also a substantial capacity test, and this is used in 19 states, and it's a little bit more relaxed. It's basically saying because of a mental defect, the offender had a compulsion to commit the crime. So what could happen here is they know what they're doing is wrong, but they have an irresistible impulse that's uncontrollable. And finally, some states allow a plea called guilty but mentally ill, or a finding of guilty but mentally ill. This is where the mental illness isn't sufficient to negate mens rea, but it was a considerable factor in committing the crime. What this basically does is the person is still found guilty legally, but they're mandated treatment. Just like opening arguments, we have closing arguments. This is a summary of the case, and no new evidence is presented. One thing that usually happens here is that each side will point out weaknesses in the other side's case. So once the both sides have presented their case, the judge is going to provide the jury with instructions on the law. And usually both the defense and the prosecution has met with the judge to have input into what these instructions are. The jury is then officially charged and deliberates in private. In some cases, they may be sequestered, but generally they're just told to avoid media coverage of the case. Usually we need a unanimous verdict, and that verdict always has to be beyond a reasonable doubt. If we don't have a unanimous verdict, the jury is said to be hung. The judge declares a mistrial, and the prosecutor could retry the case. Once the jury has reached a decision, they're brought into the court, and it's read in court. And if found guilty, we're going to move to a penalty phase. During the penalty phase, judges are going to decide the sentence. And in most cases, judges are the ones who decide sentences. And they do have some leeway in their decision. In a murder case, most people are going to get some prison time. Depending on the offender's history and how brutal the murder was, the length of incarceration is going to vary. So a study in the 90s found that 95% were sentenced to prison and only 5% were sentenced to probation. The average sentence in 1996 was just over 20 years. And in 2003, the median sentence, was 40 years. So just as many offenders were sentenced to more than 40 years as were sentenced to less than 40 years. Nearly 40% were sentenced to life. When you look at this data, or you certainly think about people who are sentenced to life, it makes it hard for us to determine an average sentence. Okay? If we remove lifers from that distribution, the average homicide sentence is 10 years. But again, that's not taking into account everybody who's sentenced to life. One thing to think about with murder is that in many states, murder is can be a death penalty case. So just thinking a little bit about how the death penalty has evolved over time, in 1972, in Furman v. Georgia, the Supreme Court ruled that the death penalty was considered cruel and unusual punishment. It wasn't that sentencing someone to death was considered cruel and unusual punishment, but the fact that it was done in an arbitrary and capricious manner. So one of the things the Supreme Court was concerned about is that there were no guidelines. And by 1976, in Gregg v. Georgia, the Supreme Court upheld what's called a bifurcated trial. So basically, a bifurcated trial means there's two stages. The first stage is a guilt stage, and then the guilt phase is followed by a penalty phase. During the penalty phase, aggravating and mitigating circumstances are presented. And you must find aggravating circumstances beyond a reasonable doubt in order to sentence somebody to death. The death penalty remains controversial, though, because there are gender disparities and racial disparities. In Ohio, for example, you are 1.7 times more likely to get the death penalty when the victim is white. Those who killed women were 2.167 times more likely to get the death penalty. And that's even when all the other relevant factors are controlled for. But the greatest disparity actually comes at the charging stage. So prosecutors are more likely to seek the death penalty when the victim is a white woman and less likely to do so when it's a black man. This is not based in conscious discrimination, but it comes from decisions about which cases can be won. And that wraps up the chapter on homicide in court.